uh, in accordance with the Fair Debt Collection Practices Act, subsection 1692, section 1694, and I sent them what is also known as, which is a legal document, which is a creditor disclosure statement. Now, if you wish, I can email this to you and to your legal department and have you fill it out in regards to whether or not the name and the address of the collector, name and address of the debtor, the account number, what are the terms of the assignment for this account, and you may attach any type of documentation of any records relating to such terms. Have any insurance claims been made by any creditor or assignee regarding this account? Has the purported balance of this account been used in any tax deduction claims? Please, and it will also give you the option to please list the particular products or services sold by a collector to the debtor and the dollar amount for each. And it also has a signature and a date. So, in accordance to the Fair Debt Collection Practices Act, until I have this form signed and all other proceeds attached, we're gonna have to just particularly have cooperation on behalf of TD Bank to actually fill this documentation out. Now, I don't have this particularly in email format. I have it in physical. Where could I mail it? Hmm? You wouldn't be able to send anything to me, so I'm strictly collections. I don't do anything legal. Okay. What's the legal department's address? And just a moment, let me figure out what direction I need to send it. So, your so I need you to explain to me exactly what you're saying in simpler terms. In simpler terms, it's just basically saying you're calling me, asking me about a debt. I'm telling you that particularly I acknowledge that a debt exists, but I just need full disclosure about what the specifics are in regards to the nature of federal law. That's what I'm saying in simplistic terms. So did you not go and sign for the vehicle and fill out the application for it? Yes, but I also did send documentation in with in regards to noticing that there's a such thing called truth in lending, and you do have a right to rescind if it's something that you really don't understand. Which is why me and my wife went to the dealership. So we were basically saying that. And to be honest with you, in legal terms, any contract that doesn't have full disclosure cannot be fully enforceable. That's contract law. So just because I signed something, when it became material to my interest to consider what I signed, I reserved that right. All right, give me just a second. Okay. I am which direction go, and I'm asking the supervisor, and you'll bear with me. So at this point, are you not making payments towards the vehicle? Well, according to Fair Debt Collection Practices Act, uh, I read federal law. It says particularly until this disclosure statement is actually signed, particularly by the creditor, quote unquote, with the specifics attached, I'm really not sure what I'm agreeing to. Do you get what I'm saying? Because when me and my wife, when we went to the dealership, um, and the day we actually went to go pick up the vehicle, the original signature for one of the things I believe it was for the loan agreement was destroyed. Now this is the truth. So because I reserved my rights on it, and I'm saying this on recording because this happened and she's my witness. Because I reserved my rights on it, he destroyed that contract and made me sign another one, which means that the original contract was already compromised. So I'm going back from the beginning of this whole incident because for anybody that doesn't want me to reserve my rights on the contract, that just kind of makes me a little bit skeptical. So once I because what he what he because what he was explaining to me was when I was asking him these questions, because I did ask him these questions. He was like, "Well, you have to take that up with the bank." So it's more so they received when I went to the dealership. I think it was the week before. Me and my wife went up there the week before Wednesday because we were just still trying to figure some things out. And this is right after y'all called us around that time. So I think I went like the next day. So I went to talk to Garrett at Westgate, and basically, when he explained to me, when I was explaining it to him, he basically let me know whatever questions you have in regards to your concerns, you must take that up with the bank. Basically, in short, in layman's terms, he said they got paid, y'all drafted the loan. My whole thing is, where did the loan come from? That's simplistic terms. Because to me, legally, from doing my research, it just sounds like somebody just floated a lien. Okay? So all of this has been documented. Yes, I went over it, but the dealership, as far as I'm concerned, they have already gotten their payment. Because I talked to Garrett personally, and he said they don't issue tags unless they got paid. So basically, they're they're a non-factor. He's just saying basically any other concerns I had to take it up with the bank, which is pretty much what I'm doing right now. No, I represent myself now. So I would have to send this documentation into the legal center. I mean, your legal department. Oh, okay, okay, okay. Yes. The validity of the contract is basically in layman's terms what I'm doing. But I'm seeking a remedy, um, like prior to you know, like execution or terms of expiration, and that's called a good faith effort in law. You know, where you I had to find out. Some people, they put it like this. Some people, when they owe certain things, their obligation is to just ignore it. That's not me. You know, I do everything I need to do by the book because, particularly, I don't want this A to negatively affect my credit, B to possibly have other, you know, instances happen because I'm doing my due diligence to make sure that I'm taking every step of the way to cover all bases and to see. All I'm trying to do is just get a signed debt validation disclosure statement. That's all. So in other words, I'm not saying I'm not paying or anything like that. I'm just saying I'm just trying to figure out in writing expressly on behalf of the creditor certain particulars, which I know that probably that might be the legal department's field. Well, of course, again, well, before, to be honest with you, before I signed anything, before I even stepped foot into Westgate, I inquired about a vehicle purchase, but they said that I asked them, do they do what's called a 1099-A? Positive response was yes. This is what the dealership told me. No, no. I think people get it misconstrued. Well, I'm a sovereign irrespective of signing any 1099-A. But in reality, in commerce, it's a commercial issue. It's not what people think it is. I know it's that it's called acquisition of property. It's actually specifically designed by the IRS to acquire property. So if it's for the IRS, you're still operating in a commercial capacity. You see what I'm saying? So I think a lot of people get it misconstrued. However, they said that yes, they do, which obviously means that A, it became material to them that they knew exactly what I was talking about, and B, they knew that a purchase would be made. Now, on behalf of the TD Bank, they were saying that TD Bank had to do it. So it was my job, it was my responsibility to contact TD Bank, but I didn't know that that was the lender he was going to go through. I had no idea because when I went and we actually did the paperwork, all I know is that he said it was approved, but I didn't know by which bank, which branch, which entity, never knew, you know. And he showed me like this is who I need to talk to. So yeah, so this is the financial institution commercially, not on some sovereign ideology, but commercially was responsible for floating the land, and that's the person I need to talk to for the cancellation of the debt, which is where you fill out a 1099-C, which is a cancellation. It's perfectly legal. So when people say pay, we don't really pay anything. You know, we don't. They probably didn't understand. They didn't explain it very clearly. Probably not. But go ahead. Mm-hmm. Mm-hmm. Well, it's not the dealership's problem. I don't owe the dealership according to the contract. Oh, from your department. For your department. Because I sent them a creditor disclosure statement too. So y'all not they're not the so I sent it to them physically because they're right here in Raleigh. I sent it to the actual finance department there, where they basically touch bases. So all I'm saying is, according to law, this is according to consumer law, not Keith's law, consumer law. According to consumer law, collection attempts cannot be made until this documentation is filled out. It is called a debt validation letter. Basically, I'm not I'm acknowledging that a debt exists. I just need to know where. So yes, the contract, I don't need that. You know what I'm saying? I don't need any of that. I agree, yes, but I need to know, where does the right for the creditor to claim on this? This is federal law. This is not my law. This is consumer protection law. And this is the reason why these laws exist. Because this is a very prevalent issue, and that's just me doing my due diligence. That's just the way it is. I noticed that most corporations think because you sign something, it's binding. But to be honest with you, even federal courts agree. When you sign something and it becomes material to your interest to consider what you sign, you have that right. You follow me? Yeah. So that's pretty much it. I'm not saying I'm contesting it. I'm saying I'm doing my research. And according to federal law, collection attempts cannot be made until this paperwork is signed. That's the truth. That's federal law. Other than that, if I don't have disclosure, then something's wrong. And it's not with me. I'm asking. I am asking, hey, what is the basis of it? That's all I'm asking. So, which means that full disclosure on your behalf or the behalf of the dealership must be provided for. That's just evidentiary because when it goes to federal court, when the case is actually initiated, it's going to come out anyway because that's a part of discovery in federal law. So either or, you know what I mean? Because that's what they're going to ask for, irrespective of the original contract. We're talking about the disclosure of it. That's what's necessarily needed. Get that, you know, we can remedy the situation. Capiche? All right. So, like I said, I mailed it off to Westgate, the creditor disclosure statement, and I'm glad that this is evidentiarily, particularly recorded for good purposes. And yeah, I just be waiting to hear back from Westgate because obviously, like I said, that's fine. That's okay. That's all right. You can contact. Okay. And I'll keep you posted on my end. All right. But this is my personal number, so you can call me on this number. I'll answer. All right. Take care. And that's how you take care of business.